I'm now going to introduce the speakers in no particular order, save that I know some of them have to get off to other events. We've asked the speakers to keep to strict time limits, so please do, given that there are so many of them, and I'm very pleased that there are so many of them. So I'm going to start, if I may, with Baroness Shami Chakrabarti, the former Director of Liberty and a former Shadow Attorney General. Shami, please.
Thank you, Pete. Friends, it's a huge privilege to share this platform with so many lawyers and campaigners with whom I've shared common cause over many years and who I certainly share my most core values with. I'm just sad that we're here for this reason. The late, great Tom Bingham gave us the clearest modern exposition of the rule of law. He set out 8 principles to give content to this phrase, the rule of law, to which Pete has already referred. The 5th rule, you may remember, was that the rule of law should protect fundamental human rights. That, of course, includes the right to a fair trial and the representation of your choice. And the 7th principle is that courts should be fair. It's my view that it's crystal clear that both of those principles, those golden rules that are part of the rule of law, have been violated, graphically violated in this case for everyone to see. It seems to me that we're in such polarised times at the moment. The things we once took for granted about freedom, about a liberal consensus around fair play, are now in contention. Now, in recent years, we've seen so many attacks on civil liberties, on lawyers, on judges, on the rule of law. But normally, they've come from the executive. I'm afraid we've seen governments increasingly restrict freedom to protest, even peaceful protest. We've seen, I'm sad to say, even from a Labour government recently, hopefully this will change now, attempts to further restrict the right to jury trial. We saw from the last Conservative government an attempt to legislate to overturn the Supreme Court's decision on the facts of the case, to legislate that Rwanda would be deemed safe, not just in the moment and contrary to the evidence, but for all time. As I say, these are great threats to freedom and the rule of law, but they came from the executive. How more difficult, unsettling, and delicate to handle when the threats come from within the judiciary itself. Now, I'm not someone who routinely criticises judges. I think that is a very delicate and dangerous thing to do when judges themselves, like lawyers and journalists and others who care about human rights, are so often under threat. But judges are human, and it is my view that judges have behaved capriciously in this case in a very chilling manner. Rajiv Menon is a very, very fine advocate who's devoted his life not to defending oligarchs and other wealthy and powerful people. There's nothing wrong with that. But has devoted his career to public service and to causes of profound injustice, human rights violations, actions against abuses of power, and so on. And so it is particularly unpleasant to watch his treatment at the hands of a part of our judiciary. I have not spoken about his case before for fear of doing anything to prejudice the appropriate appeal process and his legal strategy. But I think we're now approaching a moment where, under strict advice and guidance from Rajiv and his lawyers, we may need to broaden this campaign and indeed make it a campaign without at all prejudicing the trials and appeals that need to perhaps come first. But people have a right to know what is being done to the right to a fair trial when lawyers, court advocates are penalised for doing their job, and representing their clients. That's what's at stake here. So as I say, I want to hope and believe that the appeals to come will resolve this issue, and we can then resign this chapter to the history books. A terrible, capricious mistake by a trial judge, rectified on appeal. That is what I hope the outcome will be, and will be soon. But if that does not happen, then we have to go further. And for my own part, I believe that if the judiciary do not stand up for the rule of law, including an advocate's right and responsibility to make a jury speech to the best of his ability in the interests of his clients, then we will have to return to Parliament with this, as happened with the postmasters not so long ago, and that injustice will have to be rectified. There is a Courts and Tribunals Bill. I hope it will be drastically changed under the new administration to remove the parts restricting jury trial. But nonetheless, that bill has broad enough scope to legislate clearly, unequivocally, for an advocate's right and responsibility to speak freely in defence of his clients before a jury. And if necessary, I personally will bring an amendment to that bill or to any other appropriate vehicle to entrench this principle and indeed to make it retrospective. Unusual, sad that we might have to do that, but I personally am prepared to do that if that's what it takes. In the meantime, I send my respect, my solidarity, my solace to Rajiv and his team. And I'm so glad that we're all here. We're all here to stand up, be counted, and say this is a line in the sand. There is no rule of law. There is no right to a fair trial if lawyers are to be treated in this way.